The university is committed to supporting its staff in carrying out their responsibilities within an environment that encourages productive, safe and cooperative working practices. There will, however, be occasions when members of staff fail to meet the necessary standards of conduct. Failure to reach the required standards of behaviour and conduct or to follow rules and regulations may result in disciplinary action that may include dismissal. This podcast has been designed to talk you, as a manager, through the disciplinary process. Handling a disciplinary procedure correctly is crucial for any business, as getting it wrong can prove costly. The average cost of defending an unfair dismissal claim is about £20,000. If you lose, you could face paying compensation of up to £70,000. The compensatory award in discrimination cases is uncapped. It costs management time and professional fees, loss of credibility, and negative publicity for the company. Many tribunal cases are won by employees because the employer fails to follow procedures, so it's important that all managers know how to correctly follow the disciplinary procedure.
There are a number of reasons why you would use the disciplinary procedure. These include failure to maintain adequate standards of behaviour, as well as potential gross misconduct. Examples of what may constitute gross misconduct can be found in the university's disciplinary procedure. They include theft, fraud, deliberate falsification of records, or plagiarism. As a manager, you first have to decide whether it looks like the employee did anything wrong, and, if so, whether this was minor or more serious. Cases of minor misconduct are usually best dealt with by a manager quickly and informally. The manager should speak to the employee in private, advise him or her of the problem and what is required to rectify it. They should provide the employee with the opportunity to respond and then decide if any action is required. You are trying to ensure that the employee knows what the problem is and knows how you expect them to behave in future. The employee is not normally entitled to union representation at this stage. If you feel that the misconduct is more serious, or if you feel that the informal process has been exhausted, you can implement the formal disciplinary investigation procedure. Your first step should be to discuss this with your HR advisor. An investigation into the circumstances must be carried out. You will need to discuss who will be the most appropriate person to carry out this investigation with your HR advisor. If you are going to be making the final decision about any disciplinary sanction, you will need to get another manager to carry out the investigation for you. Otherwise, you might be the investigation manager. If the misconduct is serious enough, you and your HR advisor may also discuss whether you need to suspend an employee prior to the investigation, or place any restrictions or conditions to allow the individual to remain in the workplace.
As an investigating manager, you must act promptly to establish the facts and investigate thoroughly before deciding on whether to proceed to a disciplinary hearing. Delaying the investigation can make the decision unfair, so it's important that meeting times are mapped out with your HR advisor. Think about the sources for your investigation, such as employees' files, written witness statements, job descriptions, and copies of relevant emails. Your HR advisor will help you in planning this and will send out all the formal correspondence on your behalf. Written witness statements are obtained through investigation interviews with staff. An employee is formally invited to attend the interview by HR and can choose to bring a trade union representative or colleague with them. An HR team member will attend to take notes. These notes are salient points of the meeting that are sent to the individual for signature. Only after fully investigating can a decision be made about whether to drop the matter, as there is no case to answer, to deal with it informally, or to invite the employee to attend a disciplinary hearing. As the investigating manager, you will provide a recommendation on whether a disciplinary sanction should be considered, but will not make the decision of what this should be. This will be considered by the manager who would chair the disciplinary hearing should this take place. In most cases, this is the next level of manager. If this manager takes the decision to proceed with a disciplinary hearing, he or she must be clear about the specific reason for this action, because in the event that the employee places a claim, a tribunal would consider this. The employer would need to show that their decisions are reasonable based on the evidence available.
So, if the manager who would chair the disciplinary hearing decides to go to hearing, What is the next step? A member of the HR team will write to the employee to let them know the date and details of the disciplinary hearing. The letter will give notice of any witnesses that are to be called to give evidence, and will ask the employee to submit the names of any witnesses he or she will be calling, together with any additional evidence for consideration at the hearing. This will be provided to the panel at least 5 working days before the hearing. Copies of all relevant documentation to be relied upon at the disciplinary hearing will normally be sent to the individual at least 5 working days before the hearing. This documentation forms a pack that your HR advisor will agree with you as the investigating manager. The HR team will ensure that all parties who will be present at the hearing receive a copy of this documentation pack. It is important that you check whether the employee is disabled and if you need to make any adjustments for this at the hearing. A member of the HR team will work with you on this. Your HR advisor will also work with you to plan for the disciplinary hearing, particularly in planning the management case.
At the disciplinary hearing, as the investigating manager, you will present a management case which provides the information that the investigation found. A panel will consider this information. This panel consists of the more senior manager who took the decision to go to hearing and a senior member of the HR team. Once the meeting begins, the panel will make introductions and state the role of everyone in the room, as well as outlining the process for the day. The investigating manager will present the case which he or she has pre-prepared with your HR advisor. The employee will then state his or her case, including any mitigating factors. Both parties may call witnesses, and the panel can ask any questions they feel can assist them in making a decision. The panel will consider all the evidence and either adjourn to discuss and then give a decision, or provide the outcome in writing to the individual. During the adjournment, the panel will consider the seriousness of the offence and all the evidence provided. The HR team member will identify if any precedents have been set within the university. The panel will check the employee's disciplinary record. They will ask if a proposed penalty is reasonable in the circumstances. Are there any mitigating circumstances? Does the employee show remorse? At this stage, the panel will consider the appropriate sanction under the disciplinary procedure, which may be recommendations short of disciplinary action. In some cases, no formal action will be required. A formal written warning, a final written warning, dismissal with notice, summary dismissal without notice. There is right of appeal at all of these stages.
After the panel has reached a final decision on the matter, they may reconvene the meeting and advise the employee of the decision about the action to be taken and, if a warning is given, the life of the warning. The panel may decide this information is best conveyed via a letter. The HR advisor will advise as to the most appropriate method. The employee should be informed of any improvement that is required, and the manager who chaired the disciplinary hearing must explain the right of appeal. The panel must confirm the decision in writing immediately. A member of the HR team will draft a letter on their behalf and will file documentation from the hearing. Finally, remember that the line manager will be responsible for monitoring the employee's performance against any actions that have been agreed. Before we finish, I will summarise the important points for you to remember. Firstly, investigate fully and consider suspension if the misconduct appears serious. Remember that the employee has a right to be accompanied at all meetings under the formal procedure. Act reasonably, consistently, and take care not to set new precedents. Consider each case on its own merits and do not prejudge. Employees should be aware of the right to appeal and always follow the university's disciplinary procedure. Thank you for listening to this podcast. If you have any other questions or queries in regards to the disciplinary process, you can talk to your HR advisor.